Guys, we will be the International Criminal Court is now in session. The Dance de la Cour Penal International, 8 word. Please be seated. We have voices.
Thank you very much. Court officer, please announce the case.
Thank you, Mr. President. The situation in the Republic of Kenya in the case of the prosecutor against William Samuel Ruto and Joshua Arap Sang, ICC 0109-0111. We are in open session.
Thank you. Mr. Steinberg?
Yes, good morning, Your Honours. This morning the prosecution is, well, there's one change. Melissa Sims is in the place of Liche Zaga.
Thank you.
Good morning, Mr. President. Our team remains the same. Thank you.
Good morning, Your Honours. Mr. Sang's team remains the same.
Thank you.
Mr. President, Your Honours, good morning. The defence team for Mr. Ruto, who's in court, remains the same.
Thank you very much. For the purposes of our procedure this morning, there is another witness, one of the second summoned witness has appeared, and we will need to go into private session to discuss procedural matters relating to that witness. We will now go into private session.
We are in open session, Mr. President.
Thank you very much. We adjourned yesterday with the arguments being made on the prosecutor's application to have witness 604 declared a hostile witness, and their instance, Ms. Bousman was about to address the court on the matter. Ms. Bousman.
Your Honours, perhaps before Ms. Bousman rises, we were sent a schedule yesterday saying that we would break after this witness and recommence at 10 o'clock. So we don't have the right team in court at the moment. Well, there'll only be one change, but I don't know whether Your Honours are planning to change that schedule. It was sent from CMS at 16:29, saying that the second session would be from 10 to 11:30.
I see that. All right. I was wondering whether it was necessary to proceed, but I understand it is necessary because of technical matters that need to be attended to in Nairobi. So we adjourn now and come back at 10.
All rise. We will All rise. We will obey. Please be seated. Waivers as well.
Thank you very much. Ms. Bosman?
Mr. President, before my learned friend rises, can I just raise one short matter so the bench can consider it? Your Honour, I'd like some clarification from the bench. Mr. Ruto has been here all this week, and I wanted clarification. Is he required to be here on Monday, or is he released at the end of today? Of course, he had planned official duties back in Kenya, so that he was here this week in compliance with the court order. Of course, we'd very much like it for him to go back and resume those duties, and that's why I raised the application now. I raised this issue for guidance from the bench. Is he released at the end of today? He's been here 5 days. Or do you require him to be here over the weekend and then, of course, on Monday? That would, of course, cause inconvenience in relation to official duties that have already been scheduled back home.
We will get back to you on that in the course of the day.
I'm most grateful.
Ms. Bosman?
Thank you, Mr. President. Good morning. I actually have a few authorities to hand out. I won't dwell on them, but I thought for a matter of clarification, so if you could... There's like 3... Yesterday we spoke about, well, first of all, let me state our position clearly. We share all the observations already made by the Ruto defense on this. At best, this application is premature, but first and foremost, we think it should be rejected. The general position is, as we have discussed yesterday, that a party may not discredit its own witness, and they should not call a witness for the simple reason to put him down. And just to give a reference for that, that has already been discussed yesterday, one of them that I just gave out is the Limai case, 1 February 2005, at page 2736, lines 12 and 13, which is the general position set out. And importantly, at lines...
Sorry, wait 1 second. Which document are we referring to now?
This is the case of Limai, ICTY, 1 February 2005, at page 2736.
2736. Proceed.
So at lines 12 and 13, the general position is set out that, as I just said, a party should not call a witness just to discredit a witness. And at lines 17 and 18, importantly, is, as my learned colleague yesterday already stated, there's a material distinction between an unfavorable witness and an adverse one. So it doesn't it's not sufficient for someone to give unfavorable answers. It must be an adverse witness, and that must be shown, as is stated at line 20. Yesterday we heard this from Mr. Khan, and he cited the Katanga case.
But let me stop you there. Is adverse the same thing as hostile?
In legal terms, yes.
Is it? All right, continue.
You can be, there's a limited extent to which a witness can adverse, and doesn't necessarily qualify him as hostile, if that's what you mean. But in this in particular situation where a witness at least must adverse to the party in order to qualify as hostile, it's a minimum criteria. And what does that mean? It means, as Mr. Khan pointed out yesterday, that someone is not desirous of telling the truth. And again, I just referred to the references in Limai at page 2736, line 24, up to 2737, line 1. And that's also repeated at 2738, lines 3 to 7. And then there's also another reference at page 2143. I don't want to go too much into details in that. But the most important thing is, and this is also cited yesterday in the Lubanga decision cited by my colleague, this is page 89 of the transcripts, there must be a wholesale change of account. And there is no such thing in this case. It's not sufficient that someone is somewhat evasive and doesn't give the exact answers that the prosecution or the party calling the witness wants to hear. It's not sufficient that someone departs from his statement. It has to be a very fundamental change of account. And in this particular situation, we are dealing with two statements that he's given. One that is favorable to the prosecution, and another one that's recanting. And the prosecution has taken the position that the first one is the accurate one, and the second one is not. So that there is already that as a starting ground. Is if the witness sticks to his second statement, does that make him someone who departs from a statement he made earlier? And let me emphasize, because in Katanga, this is also one of I just handed that out as well, and this was also referred to yesterday. The case was it was actually much different in the sense that we dealt with a witness who was giving a lot of information, and a lot of information that he wasn't giving in court. And in fact, it went way further than what we've seen here. He didn't go into any of the details about the presence of civilians, child soldiers, existence of munition and supply. And yet, the chamber came to the conclusion that this was not a hostile witness. And they said, and this is at lines 3 to 10 in this is page 20 of your handout. I mean, this is where they say, minimizing previous declarations or statements with regard to previous subjects or answers. None of this is sufficient, or answers that are not as complete. So that's, as far as we are concerned, the standard. But we're so far from any of this, Mr. President, because we're dealing with someone who has not been evasive at all, has been answering all your questions, and there's only been one time when he said, I'm reserving my right not to incriminate myself, but when you give the explanation you did, he was very perfectly happy to answer the question. So we haven't seen a witness who's been evasive. We have not seen a witness who was not willing to answer any questions. And contrary to what the prosecution asserted, we were talking about demeanor. They said demeanor is not that important. Well, again, I have a reference for that in the Limai case that In fact, demeanor is important. And in this particular case, he had a demeanor of someone who was telling the truth, who was giving answers as he knew them well. And so we see there's absolutely no evidence of either an adverse or a hostile witness, so we are very far. In addition, the prosecution hasn't explored any of the areas they could have explored. The witness said some of it, I told them earlier, was true and some of it was not true. Until now we haven't heard what was true and what is not true because they didn't actually ask any follow-up questions. In addition, we know that the prosecution said this witness is averse to us as a party because he stopped cooperating. And he's only here because he was compelled to turn up. Which it's true that he was ordered to turn up, but he did. And there was no suggestion, been no suggestion yet that he's facing penalties if he doesn't. So he did come by his own volition. It's very important. And it's also true that he has given, as I said, he's given lots of answers, and he hasn't been exonerating any of us. He's giving his statement, and I think at this statement we should just carry on listening to what he has to say.
is inconsistent with the previous statement, so I need to explore that. Isn't that the bottom line in all of this? Has that happened?
Your Honours, in the prosecution submission, yes, it has happened, and I will demonstrate that shortly. But before I go off the point of the statement, the fact that he has confirmed, the affidavit, the fact that he has confirmed that affidavit in my submission is sufficient. It's not necessary for him to confirm, to have read out each and every paragraph. He said he made that statement three weeks ago. He knows what's in it. He confirms it. That statement recants material portions of his original statement. But it goes further than that.
But he also says, on the stand, when questioned, the witness did say, in the affidavit, some things I said in it were false and some things true.
Yes.
If I'm wrong, correct me. Also said the same thing about the previous statement. Some things in the previous statement are false. Some things I said in the previous statement are true. If that is the case, is there no necessity, even an obligation to say, okay, let's now, not everything you say in a statement might be of interest to the court. So it may well be that what you have in mind as true or false may not be of interest, but there are some things that are of interest. Let's go to those areas. I'm interested in this. You answer the question in area of critical interest to you.
Yes.
And see what answer you receive and all that. Afterwards, you say, now, wow, it's not. I've tried other means, and there was no way of getting the witness to the initial statement or what was said in the statement. So I have no choice but to do this.
Your Honours, firstly, one observation. I do not recall the witness at any time saying that anything in his affidavit was untrue.
Maybe
he did say that in his original statement there were things that were true and untrue, but the affidavit he confirmed. He said he remembered what was in it and he confirmed it. That's my recollection. As for the previous statement, Your Honours,
Mr. President, perhaps we should not just gloss over this. We seem to have different understandings of what the witness may have said. Perhaps we could be guided by counsel on which parts of the transcript did he say that he confirms that everything he said in his affidavit was true. I do not seem to have that recollection, and perhaps we could be guided to the transcript where he said everything contained in there is true. My recollection is he remembered that, yes, he made this affidavit. He confirmed that that is the affidavit he made. And I could not recall him going further than that with regards to the affidavit. Thank you. And Mr. President, perhaps we recall counsel was confusing the affidavit and the statement constantly. Even the fact that you had to prod him about that fact, that confusion remained. Thank you.
Your Honours, may I firstly observe I'm a bit at a loss as to who my opponent is in this matter. One moment Mr. Fowle jumps up, the next moment Mr. Khan jumps up. I do recall, Your Honours, saying at the beginning of the case that the counsel who is taking the witness should be the one who attends to the argument. This seems to be causing my colleagues some amusement on the other side, but I'm sure they would be less amused if Mr. Garcia and Ms. Zago started jumping up in turn to reply to their submissions. My understanding is that if lead counsel wishes to make a submission on a subject and he is not leading the witness, he should at least have the courtesy of asking the leave of the court to make such submissions. But we can look at that topic, but I would prefer not to interrupt the substance of my argument. If I may, I'll come back to that. Turning then to his original statement. It's true, Your Honours, that I haven't taken him through it paragraph by paragraph. I intend in total, something like 80 paragraphs of his statement he's already denied. Now, I haven't cross-examined him on it, Your Honours, and I am aware that in some jurisdictions there is an intermediate step which may be taken, but is not necessarily taken, which is to request the Chamber for permission to cross-examine or ask closed questions on a previous inconsistent statement. And after that, the application to declare hostile is made, and if granted, the prosecution is then permitted to cross-examine at large on issues extraneous to the statements, other issues that might be relevant to the truth or veracity of his version. Your Honours, I chose not to take that step because, in my view, far from being premature, it is crystal clear what is going on with this witness. And anybody in this courtroom who is not wearing blinkers should be able to see what's going on with this witness, in my respectful submission. And I'm quite happy to go through that intermediate step if the Chamber feels it's necessary. But I submit, Your Honours, that we are well past that point.
So you've listed a number of areas, so that something that wasn't done when you first spoke. Are there any other areas of interest beyond those areas you've already identified as of interest to you, that the witness answered questions that are inconsistent with what he said in the statement?
Your Honours, I don't have to hand any further examples other than those mentioned in the affidavit.
No, I'm talking about looking forward.
Yes, Your Honours, there are other areas, such as what became of this witness after the election. There are certainly further areas. In regards to the statement, there are various extraneous issues that have been the subject of the recent Regulation 35 request to add additional material to the prosecution's list of evidence with which the prosecution would like to confront this witness, and which we say will explain his sudden change of heart at the last moment. Your Honours, my learned friends have said this witness has not provided any exculpatory evidence. Well, I must observe that the defence's definition of exculpatory evidence seems to change depending on the circumstance. When it comes to the disclosure of evidence, all manners of evidence are alleged to be potentially exculpatory. This witness has claimed before the court that members of the prosecution are engaged, at least in his case, in deliberately falsifying evidence against the two accused. If that is not exculpatory, I would be grateful that my learned friends could place that on record, that they do not regard that as being exculpatory. Secondly, he has, for the first time in this court, alleged that he was put up to this by another prosecution witness whose name is not on record yet, but his name does appear in his affidavit as the person who introduced him to the prosecution. Again, the concept of exculpatory evidence includes evidence which will hurt the credibility of a prosecution witness. And if that is not enough, paragraph 18 of his affidavit, he states the following: to the best of my knowledge, Messrs. William Samoei Ruto and Joshua Arap Sang were not involved in post-election violence in any capacity whatsoever.
Has he said that in his testimony before the court?
Not yet, Your Honours.
All right.
But he has confirmed, I say, but we'll check that, his affidavit that he signed before Mr. Matai. Your Honours, the Katanga argument, the Katanga jurisprudence does not assist my learned friends. We've gone far beyond a witness who's simply evasive and not forthcoming with the answers that the prosecution might expect him to bring. He's a witness who has positively and explicitly recanted his earlier evidence. And again, if I may return to the Lubanga decision, which I submit is far more on point in this matter. I read previously at paragraph 19, and I do actually have copies for the Chamber. If you would like copies, Your Honours, I can hand them up.
We have found it in the meantime.
Thank you, Your Honours. Reading then from paragraph 20, which follows on from the extract I read yesterday. And this is, for the record, decision 2201, redacted in the Lubanga case, trial chamber. Whilst it is instructive to review the approach taken by other courts and tribunals to the problem presented by witnesses who substantially alter their testimony or who seek to change their written testimony, it is important that the Chamber does not create unnecessary, quote, rules of evidence, unquote, which may prove in the long term to be unhelpfully inflexible or artificial. Nonetheless, under the rule applied in other jurisdictions that a witness must have demonstrated hostility to the party calling him or her before that party can impeach the witness's credit or contradict him by other evidence, there can be no doubt that witness 15 has shown, quote, hostility, unquote, towards or is adverse to the prosecution. The change in his account is fundamental, since he has seemingly resiled from some of the central elements of his first witness statement. That fact, according to the bench in the trial chamber in Lubanga, was sufficient for a finding of hostility. No additional demeanor elements or adverse animus was required where we have that fact. I am aware that in certain common law jurisdictions they do look further, but in certain they do not.
It matter, Mr. Steinberg, that the Lubanga precedent you've now invoked may have certain circumstances in it that we have not yet seen here, and that is perhaps what counsel on the opposite side are saying. If you look at paragraph 3, for example, of the Lubanga, paragraph 3, paragraph 4, paragraph 12, paragraph 16, isn't that a situation where more or less the prosecution is being forced to proceed with a testimony of a witness as their witness? How the situation is understood, what happened? The witness at some point was excused for the prosecutor to meet with the witness again and take further statements or a statement. And after that, the prosecutor said, in light of what we've now learned from this witness, we no longer want to continue with this witness. Effectively, we want to withdraw the witness. That then created the interesting legal scenario in a purely common law courtroom where you would have, all right, what happens to this witness if the defense called the witness that the prosecutor no longer wanted to call. The defense will be put in the position of asking the witness neutral questions because it is the witness for the defense. And that entitles the prosecutor then to cross-examine the witness. And so that created that conundrum. And the prosecutor said, look at Banga, no, we don't want to call this witness anymore. And the defense are saying, no, you must call the witness. Or if you, the prosecution, no longer wants the witness, the chamber should call the witness. And then the prosecutor said, well, if that happens, we are entitled to cross-examine the witness if the witness is recalled, either because we've been forced to recall this witness or because the chamber has recalled the witness. Yeah, you see what I'm getting at?
Your Honours, I see what you're getting at, but
and then we then see, I mean, of course you would tell me that, well, the chamber also says that is immaterial, ultimately, that the prosecutor no longer wanted to call the witness. But the materiality of the matter may well be that the prosecutor is being told, well, you have to call this witness, you have to continue with this witness. And then the compromise situation might have arisen where, well, in that case, since it's not fair to have compel the prosecutor to call a witness they no longer want to call, we can give the prosecutor leeway to cross-examine. Do you think that is a fair assessment of that jurisprudence?
Your Honours, I take Your Honours' point, and obviously it goes without saying that every case is different and must be considered on its merits. But the only material difference I would submit is that in the Lubanga case, the witness recanted after he was in the witness box, at a stage where the prosecution is, as I understand it, not then free to decide whether or not to continue with the witness. I know the prosecution argued otherwise, but the court found against, the chamber found against them in that case. So the question then should be, does it make a difference whether the witness has recanted before or after he gives his evidence? Now, Your Honours, that is a question which has already been argued before, Your Honours. It was argued during the course of the summons litigation, and if I understand Your Honours' ruling correctly, it was rejected.
Does that take you now given of the Lubanga just now, and I'm not suggesting at all that it is an unreasonable take on that jurisprudence, but does it really help you in the sense that the defense are arguing that you knew quite well that this witness would be hostile if we accepted that that is where this thing is going? Is it right for you to drag the witness in for purposes of then saying, right, we knew you would not want to come, so we're getting you here as soon as you come into the witness stand, we'll declare you hostile and cross-examine you? That's the question the defense are raising for you to answer.
And Your Honours, in my submission, it's the same question that they raised on the last occasion, and the same question Your Honours argued. And if I may refer Your Honours to paragraph 187 of Your Honours' decision on the witness summons, it's decision number 1274, core 2, second corrected version. Starting at page 100, paragraph 186, the Chamber notes the defence's argument that the potential hostility of 8 witnesses limits the value of their anticipated testimonies, and the submissions made in support of witness 15 of the witness 15 fitness request. Beg your pardon. The important part is the following: the Chamber is not persuaded by these arguments. At 187, regarding the potential hostility of the 8 witnesses, until any witness has been given an opportunity to take the stand, take the oath, and take questions in examination in chief, it would be speculative to declare the witness hostile. Even then, there is no known wisdom that hostile witnesses are incapable of testifying to the truth under oath. And Your Honours, carry on. The witness deposed to his affidavit less than 3 weeks ago, after indicating to the prosecution that he was prepared to come and testify voluntarily. He was en route to meet the VW, to come to The Hague to testifying voluntarily. Over the course of 2 days, there's a sudden change of heart. There is history to this as well, which the prosecution will seek to go through with this witness, which may shed some light on his sudden change of heart. But the point is, the prosecution is not to know in advance whether the witness made this affidavit under some sort of duress, and whether or not he would stick to this version in his affidavit under oath, or whether indeed he would, as we say, come clean and tell the court what happened and why he changed his version. But there is another purpose as well. Your Honours, the issue of Rule 68 has been raised pertinently by the prosecution. And there are preliminary steps which must be taken before a witness's statement can be admitted under Rule 68. Firstly, the prosecution needs to exhaust all reasonable measures to get the witness to court. If those fail, then the prosecution has, and the prosecution can establish improper interference, the prosecution has met the requirements. If the witness comes to court, it then needs to be established whether or not the witness's false evidence is materially influenced by improper influence, threats, bribery, etc. So there are procedural reasons why the prosecution is entitled to do this. And it is not fair, we say, to the prosecution to say that just because you had warning that the witness may not answer favorably, you are then precluded from taking these necessary steps which you might require.
I don't think that is the point, really. The point is not that you may not compel a witness to come to court. The point is a witness that has not yet taken the stand and started testifying, it may be premature to start ruling that they're coming to lie or not lie, or they will be hostile. They may well come when they take the stand, prove useful or not, but there's the preliminary step of saying, okay, these are the areas I want to converse with this witness. You go through those, and then once it is clear that there's no getting anything useful out of the witness compared to what they had deposed to in the past, then we come to the point. So potential hostile witnesses becomes then a question of, all right, move from beyond the point of being a potential to being a really hostile witness on the stand. That is the issue.
Your Honours, my observation on that issue is that the issue is the same whether or not the witness has indicated previously that he resiles from his earlier statement, or whether he does so on the stand. You still need to establish that the witness is not willing to give material portions of his testimony. But it would be a very inefficient way of dealing with the matter, in my respectful submission, to require the prosecution to take the witness's evidence in the normal manner of evidence in chief through each and every issue before being permitted to go back and then cross-examine him on it. My submission, Your Honours, is that once it becomes clear that the witness has deviated and recanted on material portions, it doesn't have to be every material portions of his affidavit, the reasons why he was called to testify, it's far more efficient to, at that stage, provided the Chamber is satisfied of that, declare the witness hostile and then allow the rest of the issues to be dealt with more swiftly and expeditiously.
Shouldn't that probably should have been your starting point, by saying, look, there's some areas of this testimony so far, and here they are, where the witness has said something that are inconsistent with what the witness said in his statement. And you've done that now in your reply. And you lay it out, and you argue, is it then necessary to wait until you've exhausted all of it, or is it enough for us to proceed from here? But beyond that, there's another question the counsel on the opposite side have engaged. And that question arose from your signaling what you intend ultimately to do, or may do. And that is make a Rule 68 application. And Mr. Khan raised the matter and although Ms. Bausman didn't specifically address it, she adopted everything Mr. Ken had said. And the point is, can you really do a 68 application on this witness? The Chamber thinks it's important for us to deal with this now, so you know what you may or may not do with this witness, and that may guide, out of fairness to you, how you ask your questions and what you seek to do. Question is, can you, at the end of the process, say, Your Honours, in light of what the witness has said, in light of what you think of the witness, and that we should think of the witness, you would want to make a Rule 68 application?
Your Honours, the prosecution submits that provided the requirements of Rule 68 are met, that should be permissible. However, given the burden which Rule 68 2D places on the prosecution to establish that, in this case, the witness's failure to testify in accordance with material portions of his prior statement was materially affected by improper interference, the prosecution would, in all likelihood, not make that application at this stage. It may well be necessary to provide the Chamber with ancillary evidence to support that finding.
There are two things, so we can move quickly to it. The first issue is intrinsic to Rule 68 itself, what it says, what it is, what it contemplates. But before we even get to that, there is the matter Mr. Ken directly engaged yesterday. He says he made it a matter of travaux of Rule 68. The state's parties had indicated that Rule 68 should not apply to ongoing cases. I think it's more than travaux as such. The resolution adopting Rule 68 says in paragraph 2, don't know if you have that, the resolution, but I can read it.
I don't have that before me.
Right. Let me read it. Paragraph 2 of ICC-ASP/12/Res 7. And paragraph 2 says, further decides that the following shall replace Rule 68 of the Rules of Procedure and Evidence, emphasizing, and indeed the word emphasizing is emphasized, emphasizing Article 51, Paragraph 4 of the Rome Statute, according to which amendments to the Rules of Procedure and Evidence shall not be applied retroactively to the detriment of the person who is being investigated or prosecuted, with understanding that the rule as amended is without prejudice to Article 67, and so on and so forth. But here, the adopting resolution explicitly says, emphasizes that paragraph 51, Article 51, paragraph 4. Let's look at what it says. Article 51, paragraph 4, it says, the Rules of Procedure and Evidence, amendments thereto, and any provisional rule shall be consistent with this statute. Amendments to the Rules of Procedure and Evidence, as well as provisional rules, shall not be applied retroactively to the detriment of the person who is being investigated or prosecuted or who has been convicted, unquote.
Thank you, Your Honours. Yes, the prosecution is well aware of that provision. The first document of the ASP which you read out does nothing more, in my respectful submission, than direct the reader to 51.4. Now, perhaps a full argument of this point may, in my respectful submission, be beyond the scope of this hearing, because it's something which parties might want to give a full written argument on. But my submission is that, as it stands, Article 51.4 presents absolutely no bar to the Chamber applying Rule 68 in this case. What Article 51.4 does not say is that an amendment to the rules may not be applied to an ongoing case, which is what my learned friend suggested when he argued on the matter the other day. What it says is it may not be applied retroactively to the detriment of the accused person. And there are two parts to that argument. One is it may not be applied retroactively, and secondly, if it is applied retroactively, it may not be to the detriment of the accused. Both of those, it's a combined prohibition, as it were. The prosecution's submission is that the Chamber is not engaged in any form of retroactive application of this rule. And the important point to remember is that, Your Honours, this is not a penal statute. It is a procedural rule. Now, the rules, the general principles of legality say that penal statutes may not be applied retroactively. The rationale behind that is that people should be aware at the time that they commit or perform certain actions that they might be punished for those actions, and it would be unfair to subsequently decide that it may be a crime to step on the cracks, and someone steps on the cracks and tomorrow he's prosecuted. But this is a simple procedural matter.
I want to understand you, your interpretation of retroactive. So there are two things. First, what is meant by retroactive. Before we do that, let me make this very clear. The reason why I raise this matter now, you say it may be beyond the scope of this application. It's up to you, really, in a way, because there's a sense in which it may be in your interest for a determination to be made, so you know where you stand. You don't want to be in a position where a decision is made on 604, and then when we get through your application on whether you can use the statement under 68, and that decision may not be in your favor, and then you complain that, well, had I known, I might have organized myself differently. That's why it may be fair to you to have this out of the way so you know where you stand on 68. Don't you think?
Yes, certainly, Your Honours, that would be helpful. Of course, it would have been far more helpful if I'd had a notice of this issue, but it happens that I have given it some thought, and I may certainly address some preliminary remarks on this question. If we're limited to the question at the moment of any bar to the application of Rule 68, I think I can address that point at least.
So with that clarification, remember that was a clarification along the way to one question I was going to ask you. And then you say retroactive, that the provision 51.4 says amendment may not be applied retroactively to the detriment of a person who is being investigated or who is being prosecuted, who hasn't. And you say that, what? Sorry.
Your Honours, what it doesn't say is the provision may not be applied to a person who is being investigated, who is being prosecuted. It may not be applied retroactively to the detriment of such a person. So it is the issue of retroactivity and the fact that it's being applied to the detriment with which I take issue. Obviously, I don't take issue that we are looking at a person who is being prosecuted, or persons who are being prosecuted.
What is the first part of it, before we come back to the second limb of your observation, who is being prosecuted or investigated. What is your interpretation of retroactive in the context of adoption of a rule, an amendment in the middle of an ongoing case?
Your Honor, if, for instance, a rule were brought in dealing perhaps with, under, say, Article 71, which made certain conduct that an accused might have done an offence for which he might be punishable, that might be a retroactive application. But here we're dealing with a procedural matter. It's a matter related to the court's determination of the admissibility of evidence. The rule is in place. The rule is in place. It's been in place since November last year. The prosecution are seeking to rely on that rule now, 9 months, 10 months after the rule is put in place. The prosecution says this is not retroactive application. We're looking at present facts, many of which didn't even arise at the time the rule was changed. Secondly, this is not, well, that's the first on the issue of retroactivity. With respect to procedural regulations and rules, the prosecution's submission is that provided the regulation or procedure is in place at the time, either party, not just the prosecution, either party, the defense can rely on this rule too, at the time the party wishes to rely on it, that does not amount to a retroactive application. If, for instance, the Chamber had rendered its final decision on the case, or let's say at the end of the prosecution case, the defense brought a no case to answer motion and the Chamber upheld it. If at that stage the prosecution then said, but wait, I have more statements I want to hand in, that might be said to be a retroactive application because a certain stage had been reached, a ruling had been made which would have to then be undone. And that would, I do not quibble with, that would be a retroactive application. But at the moment, we are in the process of a case. A problem has arisen regarding witnesses not wishing to come to court or not testifying according to their statements. A remedy is available at that time, and the application of that remedy at that time, in my submission, would not be retroactive. On the issue of whether or not, well, so it fails on the first leg in my submission, but even if it could be considered to be a retroactive application, my submission is it is not to the detriment of the accused in this case. Firstly, it is the retroactive application that must be to the detriment of the accused. It is not sufficient that the accused is faced with incriminatory evidence. The material which the prosecution seeks to hand in, or will seek to hand in, is material that the accused have always been, to their knowledge, at risk of being confronted with during the course of the prosecution case. The statements that the prosecution will seek to tender form a significant part of the basis of the document containing the charges. They've all been disclosed to the defense many, many months ago, and there should be no element of surprise here. The prejudice which may arise, of course, is the fact that in the case of certain of these witnesses, not this witness, but certain other witnesses, if they don't come to court, the defense may be deprived of an opportunity to cross-examine the witness. But that is a matter of prejudice as a result of the application of the rule, but not as a result of the retroactive application of the rule. And it is a matter which is catered for specifically in Rule 68, because one of the factors which the Chamber is required to consider is whether or not the interests of justice would be served by allowing the prior recorded testimony to be introduced. So it is at that point that such prejudice should appropriately be considered. Court will bear with you one moment, please. I also observe that the rule has other important safeguards, such as the threshold which the prosecution must cross before the documents may be admitted, and that is to establish, in my submission on a balance of probabilities, that there has indeed been improper interference, and that that has materially affected either the non-appearance of the witness or his failure to testify on material portions of his evidence.
The next point, the next question I have for you, as I said, that I had questions in two areas. One is the extrinsic circumstance of 68, which we've seen addressed in Article 51.4, and the second is the intrinsic question of Rule 68. Is it about statements or testimony?
Your Honour, in my respectful submission, prior recorded testimony includes witness statements. And this issue, if I'm not mistaken, I don't have the references exactly to hand, but this is a matter or a concept which is not foreign to the ad hoc tribunals. And I speak under correction, but I'm fairly certain that there is authority in the ad hoc tribunals to the effect that prior recorded statements include witness statements. But in looking at the wording of Article 68.1, from line 3, allow the introduction, the trial chamber may, and I read from line 3, allow the introduction of previously recorded audio or video testimony of a witness, or the transcript, or other documented evidence of such testimony. Other documented evidence. In my submission, the plain language of that, having distinguished it from audio, video, and transcripts, can only mean, or certainly encompasses, prior statements made by the witness.
Now let's take that again. Let's begin from the beginning. When the pre-trial chamber has not taken measures under Article 56, the trial chamber may, in accordance with Article 69, paragraph 2 and 4, and after hearing the parties, allow the introduction of previously recorded audio or video testimony of a witness. Let's stop there. So far, it's talking about audio or video recorded testimony.
Yes.
It isn't yet talking about transcript.
No.
And then we continue, the second part. Or the transcript or other documented evidence of such testimony of a witness. So, on each occasion, provision seems to be talking about testimony, either audio or video recorded, or reduced to transcript, or there's other evidence of testimony.
Your Honours, I do understand that again in the Labanga case, there is a decision on this matter. If I may just find the reference, please. From this document?
In fairness to you, as you rightly pointed out, you were not given prior notice of this argument, but then the defense will say, well, you should have known what the provision says, including 51.4. The point is, I make is, in order that we're all fully on board with what the law is and what the thinking is. You may, in the course of the testimony of this witness, we may, if you see that it's necessary to return to this after you've done further research, we can entertain that briefly.
Thank you, Your Honor. But I
found
found
I wanted to flag that it is in your interest to know where you stand on it, so you're not caught by surprise at the end of when you want to do a 68 application down the line.
Your Honours, I'm grateful, but I have found the reference I was looking for. Perhaps I can just draw Your Honours' attention to that in the meantime. It is a Labanga decision, which is decision 1603, from paragraphs 18 to 19, which holds that Rule 68, quote, is directed at the testimony of a witness in a broad sense, given that the various forms of testimony that are specifically included in the rule are audio and video records, transcripts of other documented evidence. I think that should read or other documented evidence. Yes, transcripts or other documented evidence of such testimony, namely the testimony of a witness. So the Labanga chamber interpreted such testimony to mean the testimony of a witness, but not limited to the audio or video testimony of a witness. The chamber highlights particularly that the, quote, other documented evidence, unquote, in brackets, of the testimony of the witness, close brackets, is referred to separately and in addition to the audio or video records in the opening paragraph of Rule 68. Moreover, in sub-rules A and B, as they were at that time, previous, quote, previous recorded testimony, unquote, is referred to without limiting its scope to video or audio evidence. Against that background, the Chamber is persuaded that the ambit of Rule 68 permits the introduction of written statements in addition to video or audio tape records or transcripts of a witness's testimony, because they are all examples of the, quote, documented evidence, unquote, of a witness's testimony, close final quotes. The Katanga and Ngujolo decision.
Does Katanga, was that Lubanga you said?
That was Lubanga, Your Honours.
Did it define the term testimony?
Your Honours, I don't have the original. I'm quoting from an extract in a memorandum, so I don't have the original with me, unfortunately. I can't answer that question. I don't know that it does. But it may be observed, Your Honours, that testimony does not necessarily refer only to evidence given in a court of law under oath. I think.
But I don't think you get an argument on that. An affidavit, for example.
Yes.
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 May come in
and
under a definition of testimony. An affidavit made on the road.
Your Honours.
Does it mean that every other statement comes in as well? The police officer at the crime scene.
Your Honours, I wouldn't necessarily say that every other document, but certainly a document in the nature of an affidavit. And I would observe, Your Honours, that statements are taken by the prosecution in this case in one of two manners, generally speaking. Either a written statement will be taken which is read back to and signed by the witness who acknowledges and confirms the correctness of that statement. Alternatively, for witnesses who are considered at risk of incriminating themselves, the statements would be audio recorded and subsequently transcribed. In my submission, it would be very strange if the latter were admitted but not the former, for the only reason that it was recorded. Both of them amount to statements given by a witness solemnly to the prosecution, acknowledging that they affirm the correctness of the contents. Referring then, while I'm on my feet, then to the Katanga and Ngujolo decisions, these identify other bases of support, and I quote from decision on the prosecution's bar table motion I don't have the decision number, unfortunately, but I can find that. It's paragraph 44 of that decision, which says the following. Clearly, statements made out of court can equally qualify as testimony. In fact, was what we were talking about. This is apparent from the wording of Article 56(1)(a), which refers to, quote, a unique opportunity to take testimony, unquote, and of Article 93(1)(b), which expressly mentions the taking of evidence, quote, including testimony under oath, unquote. In the context of assistance provided by state parties, again quoting, in relation to investigations or prosecutions, unquote. Moreover, a narrow interpretation of the word testimony in Article 67(1)(a) would entirely undermine the very right protected by this article and deprive Rule 68 of any meaning. Bear with me one moment.
Is there a question of fairness arising for a witness if testimony is given that broad an acceptation? So a witness, for instance, being interviewed by a policeman and the witness is perhaps not telling the truth for any reason, either to exonerate themselves or for whatever reason, at the end of which the witness signs the statement after it had been reread, and it's, yes, this is my statement, the witness signs it. And later on, do we not have an issue for the witness, so, well, now you can be prosecuted for perjury because this is testimony?
Your Honours, I submit that that does not really arise, because the definition of perjury, certainly in my jurisdiction, would be evidence given under oath, false evidence given under oath.
So that was the definition of testimony as well?
Your Honour, no. My submission is that it goes broader than simply evidence given under oath, remembering that the prosecution, the practice of the prosecution in this institution is not to take evidence under oath.
Is it defined by the practice of the prosecution or an objective legal standard of what testimony is?
Your Honours, what is a crime is defined by the definition of a crime. The crime, certainly in this court, under Article 70, is giving false evidence having been warned under Article 69. So a witness in this court who gives a false statement to the prosecution, unfortunately, is not liable for prosecution under Article 71A, because only the court is given the power to administer that oath. And it's a matter which I've long decried, and maybe a matter which the Assembly might wish to revisit in its wisdom in due course. Because in my submission, many of the difficulties in this case might have been dealt with, and I don't think my learned friends would argue about this, if witnesses were at peril of prosecution for giving false statements at peril of prosecution for giving false statements to the OTP.
Can you look at Article 70 sub 1A that you just alluded to?
Yes, I have it.
Right. It is a crime to give. I'll take it. The court shall have jurisdiction over the following offences against its administration of justice when committed intentionally. A, giving false testimony when under an obligation pursuant to Article 69, paragraph 1, to tell the truth. Does Article 69, paragraph 1 really add anything when you look at it? What does it do?
Your Honour,
69, paragraph 1 says, before testifying, each witness shall, in accordance with the rules of procedure and evidence, give an undertaking as to the truthfulness of the evidence to be given by the witness, basically the oath.
Yes.
Isn't that it?
Yes, Your Honours, but interpreting this provision in its context, which is under Part 6, which deals with the trial, the interpretation that, prevailing interpretation, as I understand it, is that that applies to testimony before the court after an oath is given by the judge, by the bench. So
you say that your point is that on that basis, before this court, such a witness, no witness may be prosecuted if all they did was give a statement that was deemed to be a testimony by some legal mechanism. What about prejudice to the witness outside of this court? If there is some law that says anybody who gives false testimony may be prosecuted. Say, for example, it wasn't the prosecutor that took the statement from the witness, but maybe the prosecutor received assistance of a state using the national mechanisms to obtain statement from the witness. Under the national mechanism, can the witness not be prosecuted?
Your Honours, my submission is that these hypotheticals do not affect the definition of testimony for the purposes of Rule 68. Whether or not a witness is liable to prosecution in their national jurisdiction is an issue which is quite separate from the determination of this chamber about whether or not his prior statement amounts to testimony. That's my one observation. But again, I can't speculate as to that because it would all depend on the law in that country. Whether the law in that country would recognize a statement made to the prosecution under a solemn declaration, I think we can refer to it as liable to prosecution for perjury, or whether or not they require a higher standard. But my submission is that it's a very fascinating argument, but perhaps one that need not engage us for present purposes.
Well, you can see it as fascinating. I have a feeling that counsel for witnesses may not think it's fascinating or beyond the realms of something that should worry them. But if you finish speaking on the matter, we can leave it at that.
I think for now that has exhausted my reserves.
Ms. Ken.
I'm grateful, Mr. President. If I may, dealing briefly with the first matter, my learned friend once again has referred to the Lubanga case, and Your Honours, the defence can do no better than to, with the greatest respect, endorse the position postulated by Your Honour at paragraphs 3, 4 and 12 as to the distinguishing features that led the Lubanga trial chamber to make the decision that it did. But Your Honour, in assessing the merits of the application of the prosecution, we say it's important to step back. And what is the purpose? There's no magic in a label, hostile, or even in cross-examination. The prosecution have said, the defence have said, and the bench have reiterated on many occasions that one of the key objectives is to get to the truth. And Your Honour, at paragraph 19 and 20 of the Lubanga decision, the learned trial chamber were very clear that one of the reasons why they allowed, apart from the issues of fairness that Your Honour referred to in the earlier part of the decision, they said not allowing the prosecution to cross-examine would potentially impede the chamber in the pursuit of the truth. And similarly, at the end of the paragraph, if the prosecutor is restricted to neutral questions, he would be unable to explore adequately the circumstances of the change of account. Your Honour, we say that's important because there's been really, if not no attempt, a very scanty attempt by the prosecution to attempt thoroughly to sieve out truth and fiction from any previous accounts from the witness. And, Your Honour, that can be done by way of neutral questions. Your Honours have, will of course be alive to the fact that we're not here judging the veracity of an affidavit or the veracity of a previous statement given to the prosecution or domestic authority. what the court wants to do and is to encourage witnesses, hence the importance of the Article 70 warning, is that you have a most onerous responsibility. This is a sombre occasion to speak the truth, knowing that the consequences, that the court is assessing that evidence. And Your Honour, that's why the key objective must be getting the truth and a full account as possible from the witness in the box. And Your Honour, given even the Lubanga decision, I referred yesterday to Katanga, Your Honour, there's been no persuasive reason, we respectfully submit, as to why the prosecution can't make further and proper investigations by way of non-leading questions. There's no persuasive reasons why leading questions are necessary in order to allow the trial chamber to get to the truth. That can be done in the normal way, as we do with normal witnesses. And Your Honour, let me give you an example. The witnesses said parts of the testimony are true, parts are false. Maybe the same with the affidavits. That can be inquired into. Your Honour, in previous occasions, the prosecution have been extremely...
But what the prosecution is now saying, they didn't begin with their submission with that when they made the application, first run of it. But in reply, they've now pointed out, saying, here are some, we've done neutral questions here. The answer we received from the witness is inconsistent with what the witness said in the statement, a lot of it. We've done neutral questions there, and it's inconsistent. We've done it here and there, it's inconsistent. So they've now outlined areas in which they have asked neutral questions and did not got an answer that they say is materially inconsistent with, or fundamentally inconsistent with the testimony testimony that's inconsistent with what they have in the statement. The question then is, should they continue to ask neutral questions in all the other areas of interest to them, or is it say, well, there's enough now to consider whether to allow the prosecution to really go all out and try and get to the truth, as you say?
Yes. Well, Your Honour, one of my submissions yesterday that it was premature. The application was premature because the prosecution haven't done that which is necessary, even on their own case, we say, to declare a witness hostile. Your Honour will recall, the bench will recall, that on several occasions during the witness's testimony, when a question was posed, my learned friend Mr. Steinberg says, I'll come back to that. On many occasions, or at least on one or two occasions, the witness said, I can't remember. Your Honours will recall well that in previous witnesses, the prosecution couldn't wait to refresh a witness's memory. Why on earth now are they so reluctant to refresh a witness's memory that says, I can't remember? Your Honour, so what we say is important, given the nature of the account, and there'd be no objection to it. Whatever the term of art is, one wishes to ascribe to it, the prosecution can ask certain questions, and if the court give leave, can say, okay, Mr. Witness, you gave a statement. Is this the statement? Yes. You said this. Why did you say that? And get an explanation. Your Honour, if the witness is not desirous of telling the truth, if the witness is refusing to answer, contumacious refusal in the face of the court, certain action may be taken. But we don't need to jump to discredit a party's own witness. Your Honour has already pointed out one of the many differences between this and the Lubanga case. The prosecution have conduct of their case. They make their strategic choices, not us. And they chose to call this witness, notwithstanding the affidavit. Now, Your Honour, this is not contrary to the summons, because what Your Honour's decided in the summons is that a witness should be called. It didn't deal with the modalities of questioning, and so they are completely unrelated aspects. So, Your Honour, that's my submission in relation to hostility. If we want to get to the truth, let the witness explain, and it can be done in a methodical manner. You've said this? Did you say that? Yeah, okay. Is it the truth? Yes or no? If yes, they've got it. If no, why did you say it? And, Your Honour, that's the proper way to do it. And, of course, the court can keep it under review. The prosecution can make other applications later, but they're jumping the gun, which is why I said yesterday it's premature, and for that reason it should be defeated. Your Honour, in relation to the Rule 68, Your Honour has turned, in fact, to the correct document in the Assembly of State Parties, and my learned friend's attempt to say, well, it's a procedural rule, should be given short shrift in relation to Article 51. It was for that very reason why the Assembly of State Parties wished to underscore and emphasise the importance that that rule would not be used by the prosecution in ongoing cases. And Your Honour, Ambassador McKenna is in the gallery. She was the representative of Kenya at the Assembly of State Parties. I said a couple of days ago, I think it was a couple of days ago, that it's bad faith of the prosecution.
Let's not bring Ambassador McKenna into it. Just make your submission.
Your Honour, I said it was bad faith because the prosecutor was present. They have the statute talking about non-retroactivity. This is consistent, in fact, with the ICTY rules of procedure and evidence, which Rule 6, I think it is, says that a rule change will not be applied to the detriment of an accused. A rule change. But, Your Honours, the Assembly of State Parties made it even clearer that it applied to a specific procedural rule, so the argument that it shouldn't apply because it's procedural really falls flat on its face, we say. The Assembly of State Parties wished to emphasise it, and it was passed on undertakings that it would not be used in relation to ongoing cases. And for the prosecution, and the prosecutor herself and her representatives were present in that ASP, to now seek to put forward arguments that somehow they wish to do that which they know is not allowed, we say is regrettable, and I've said bad faith previously. Your Honour, the other aspect, Rule 68 doesn't even apply at all to this present case, because the witness is here. And Rule 68 too, of course, primarily is talking about evidence of a witness who is not before the court. But, Your Honour, even when a witness is before the court, if one looks at 68 to D1, the prosecution, and this again supports my argument about the proper procedure, they haven't said, witness, you've said this, can you explain? And so the witness has not failed to give evidence with respect to a material aspect, including in his prior statement. The prosecution are not even attempting to go there. Instead, they want to introduce, they've said repeatedly, what we've called a wild goose chase, Article 70 and other matters, to controvert the witness. Let's stay focused on the PEV, the veracity of the account, because the prosecution said, and it's their own words, why would anybody interfere with a witness that's not telling the truth? We agree with that, actually. But, Your Honour, we say that the prosecution have failed to understand the proper ambit of Rule 68, how it applies in the present circumstances, and it's directly linked to the proper procedure that should be adopted with the witness that Your Honours have before you. I'm grateful.
Thank you, Mr. President. Again,
If you don't need to add to it, you can just adopt things. And
I will adopt everything that's been said, but I have very few things to add. If we are speaking about Rule 68B, well, we have already one commentary who says that the non-retroactivity applies to the definition of crimes as well as the general principles of the procedural and evidentiary regime. This is Shabazz in his commentary on the Rome Statute. I'm sure we will discuss this at a later stage. I just wanted to point that out. But and Rule 68B, according to your own decision, and this is number 847. This is the decision on conduct of proceedings.
How much longer? Not that you've spoken too much already, just that we actually streamed past the break point. 2
minutes?
All right.
This is your decision on the conduct of the proceedings, number 847. And let me just read out paragraph 28, which states that when a party wishes to introduce prior recorded testimony in accordance with Rule 68B, it shall file an application to that effect at least 21 days before the witness is scheduled to appear. So I think in any event, this rule cannot apply to this particular situation. In addition, just one line, I do agree, but it is particularly I think testimony is clearly in not just in my view or in yours. We can find authorities sworn testimony, which is not what we have, and it's particularly delicate when you want to rely on a prior statement if someone later on recants. There is a real prejudice there, and the only case I can think of this has happened before in the ICTY. This was when it was all recorded. We had a video recorded. This was the most important aspect of that decision. I can cite it for you. I'm a bit worried about the time. The reason why they said we can tender these statements because we can see the demeanor from the video, and at the end of the day in their decision they did not rely on these witnesses because they were not trustworthy. We are not in this situation. As I said, Rule 68 doesn't even come into it, and it would be incredibly unfair if we would go that route.
Thank you. We will adjourn now, but 1 second. We will adjourn now. We will come back at 12:10.
All rise. We will. All rise. We will obey. Please be seated. We will swear.
Thank you very much. We will make our ruling on the prosecutor's application to declare witness 604 a hostile witness at this stage. Before making that ruling, I want to declare that we're not yet going to make any ruling on the applicability of Rule 68. It is something that we'll take up again if the need arises to do that, but it was useful to signal whether or not there may be a fight on that matter when the time comes, fight between the parties on it. To that extent, that is the extent of the exercise on 68. But now the ruling on whether or not those witnesses to be declared a hostile witness. We have an obligation, the Chamber, to strike a balance that takes all appropriate interests into account, including, of course, the interest of the witness under Article 68. To that end, it is important to reduce as much as possible the state of affairs in which the witness is subjected to cross-examination by every counsel who asks him questions. So I say, to the extent that it is possible to avoid that, that would be the best course. He may well come to the point where that is what happens in the process, especially if there is a risk, a real risk of jeopardy to the search for the truth. But the Chamber's position is that it is premature at this stage to declare this witness a hostile witness, without prejudice, of course, to the facility to the prosecutor further on to revisit the application if he considers it necessary to do so. But in the meantime, we know that the prosecutor has already indicated areas in which he has elicited testimony that appear inconsistent with what the witness had deposed to, or rather given to in a statement to the prosecutor. It's important that the prosecutor also continues to explore other areas of interest, of critical interest to the case. That is the ruling of the Chamber at this time.
As the Court pleases, Your Honours, may I just seek one point of clarity? Your Honour mentioned in the course of argument the possibility of exploring previous or the prior inconsistent statements through asking closed or leading questions. Is it Your Honour's ruling that at this stage, the prosecution may resort to that technique, or that I should continue to lead the witness as a normal prosecution witness at this point?
1 second. The clarification, first of all, is, of course, to cover other areas, broadly speaking, that the prosecutor wants to explore, and these, we have those areas. Within that, there is good sense in seeing whether or not a little more prodding through the other methods may work, including the possibility of refreshing memory. But these things are not set in stone. It's a human process. At some point, there comes a point where a determination needs to be made either by the prosecutor or apparent to the judges that it may be a wasted exercise to do it. So if that is the case, but until we see, let's try and see if that is what is happening or not.
Thank you, Your Honours. I'm so guided.
We will now bring in the witness, and we will go today until 1:10 and then we are, but no later than that, for our luncheon break.
As Mr. President, the witness will be escorted in.
Thank you very much.
Mr. President, the witness has been brought inside the transmission room.
Thank you very much. Witness, welcome back. We are back in open session, and the prosecutor will continue asking you questions. I remind you again, please try and observe the pause. Wait for the prosecutor to finish his question. Count to 5 in your mind before you start answering. Also, be mindful to not indicate, when we're in the public session, to indicate information that might reveal of your identity, might be revealing of your identity. Okay?
Yes, Mr. President.
Thank you. Mr. Steinberg, please proceed.
Thank you, Your Honours. Good morning, Mr. Witness.
Good morning.
Mr. Witness, just by way of reminder, you are, of course, still under your former oath that you took yesterday. Do you remember that?
I've not got a new one.
I'm reminding you that you are still under the oath to tell the truth that the learned judge, the learned president referred you to yesterday. You understand?
Yes.
Thank you. Mr. Witness, just before we adjourned yesterday, we were dealing with a document, an affidavit, that you had attested to in the presence of your lawyer, Mr. Mutai. Do you recall that?
Yes.
And just so there can be no misunderstanding, you confirm that you're familiar with the contents of this statement, this affidavit?
Yes.
In fact, I presume you have a copy of this affidavit, is that right?
Yes.
And again, so there can be no understanding, what do you say about the contents of this affidavit here before the court? Is it true, or is there anything in this affidavit which is untrue or incorrect? I'm referring the affidavit you made before Mr. Mutai. Do you understand the question?
Mr. President, I think the affidavit is about 3 pages. And it's only fair that it be put in front of the witness and let him have a look at it in order to be able to assess whether there is anything in it he does not wish to confirm to be correct or not. Because now, as it is, it's like he's just speaking from a vacuum. He does not have any reference to the affidavit. It's difficult for him to say at the top of his head that everything in it is correct.
Mr. Steinberg.
Your Honours, we're dealing here with a two-page and 3-paragraph affidavit that was made 3 weeks ago, an affidavit that the witness is in possession of. As a general matter, I will come to the specifics. But as a general matter, I would like to ask the witness, as he sits there now, whether there is anything he knows to be incorrect in his statement. Maybe I should take it at that level first.
But the objection, rather, is whether that the document be put in front of the witness so that he is looking at it. Is that not a fair point?
Your Honours, it is a fair point if one is to test the minutiae and the correctness of the minutiae. But let me ask him, if he's told any falsities in this statement, that is something which is not a question of memory. He should know exactly what that is. So let me first deal with the truth of the affidavit, and then we can deal with the reliability and the accuracy in the manner my learned friend suggests. That is my proposal, Your Honours.
Let's have the witness answer the question, Mr. Let's see how it goes.
Thank you, Your Honours. So, Mr. Witness, let's start with the question. At the time you gave this affidavit before Mr. Mutai, were you satisfied that what you were telling him was the truth, or is there anything that you told him which was, to your knowledge, false?
It is true.
Thank you, Your Honours. And what was the reason why you decided to attest to this affidavit?
Because I knew that the evidence I had recorded was false. So I didn't see any need of going and testifying something which I knew it was false.
So, well, certainly one of the main purposes you now pointed out was to establish what was false about your statement that you made to the ICC investigators. Is that right?
Yes, it is right.
And what about the reasons for your making that false statement? Did that have anything to do with your making this affidavit, to tell why you had made a false statement?
Sorry?
You've told the court that you wanted to make a statement to the effect, you wanted to make an affidavit to the effect that your original statement was untrue, correct?
Yes.
I notice in your affidavit you give certain reasons why your statement was untrue, why you gave an untrue statement to the investigators. Was that also one of the reasons for this affidavit?
Yes.
And I presume then that you would have told your lawyer all the important facts surrounding why you made a false statement and what was false in the statement. Is that fair?
I'm not getting you well.
Was it important to you that all the important information relating to why you gave a false statement to ICC investigators was recorded in your affidavit? You understand?
If you still do not understand, you can say so.
Yes, I still don't understand.
Okay. You told the Chamber a moment ago that one of the reasons you gave this statement was to explain why your statement to the ICC investigators was false. Correct?
Yes.
And in fact, you talk in this statement about certain promises that were made to you by the investigators. You remember that?
Yes.
Was it important to record all the details of why you gave the false statement? All the important details?
I didn't have the statement by myself, so I couldn't point out which were facts and which were false.
Well, for the time being, let's accept that. But I'm not talking about now what was false in your statement. I'm talking about why you gave the statement which was false. You understand? You understand the difference?
Yes.
So I'll repeat the question. Was it important for you to record in this affidavit all of the important reasons why you gave a false statement?
Still, I'm not getting you.
I think perhaps this is a matter which I might return to at a later stage in a different way.
Do you witness? Are there other reasons? Are there other reasons why, in your mind, you gave the false statement to the prosecutor? Which other reasons you have not indicated in the affidavit that you swore? Do you understand that question?
Yes, Mr. President.
That is, are there additional reasons that you did not include in the affidavit?
But, Mr. President, this is why I thought that it was only fair that the affidavit be placed in front of the witness so that he could, in his mind, check whether there are other reasons and whether those reasons are contained in the affidavit or not.
Mr. Steinberg, is that the question you were driving at?
That was the destination, but not the starting point. The starting point that I'm trying to establish was whether or not, in the witness's mind, at the time he made the affidavit, he appreciated the importance of giving a full account of the reasons why he deposed or gave a false statement to the prosecutor. The contents was then a follow-up question which I was leading to. But perhaps I can answer this question. I can ask this question. Now, this is not a statement that this is not an affidavit that you drew up yourself. You drew it up with the assistance and advice of your lawyer, Mr. Matai. Is that correct?
Correct.
And you knew that this was a statement that you would have to swear to the truth to? Is that right? You knew that you were going to take an oath as to the truth of this statement?
The affidavit.
Affidavit. Affidavit, I beg your pardon.
Yes.
And in fact, at paragraph 20, it's stated that all that is stated herein is true to the best of my knowledge, information, and belief. Is that correct?
Yes.
Did your lawyer explain to you the importance, then, of accuracy in an affidavit that you were going to take an oath as to the correctness and truth of? Did you understand it was important to be accurate in what you said?
Yes.
Thank you. Mr. Court Officer, may I please ask that you call up this document at this time? The ERN is KenOTP 01351135. And the page I'm looking for is 1137, please. While that is coming up, Mr. Witness, can I just ask you this question? You say you have a copy of this statement. When last did you read through it, this affidavit?
On Tuesday.
Tuesday this week?
Yes.
So it's fair to say, isn't it, that you have a very good idea of what's contained in this affidavit?
Yes.
Mr. Court Officer, can you confirm when it's on the screen, please?
I confirm that the document as referenced by counsel at page 1137 is presented to the witness.
Thank you, Mr. Court Officer. Can I ask you, please, to read through the paragraphs 1 to 7 as they appear on that page? Let us know when you're finished, please. Can I just have confirmation that you can hear us because the picture is frozen?
Yes, I hear you.
Thank you. Then I can't see you, so please let me know when you finish reading. Disconnected. Your Honour, I see we've disconnected. You finished reading, sir?
Yes, I finished.
All right. Now, getting back to the question which His Honour the President posed to you earlier, does this statement accurately reflect the reasons why you gave a false statement to the ICC investigators?
Yes.
And does it completely describe the reasons why you gave the false statement, or is there anything you've left out?
For now, I don't think I've left. I don't think I left anything out.
Okay, you're satisfied with that version, correct?
Yes.
All right. Can I ask you, please, to turn to the court officer to call up the next page, which is ERN 1138 of the same series.
Page 1138 is being presented to the witness.
Thank you. And I direct your attention to paragraph 8. If you could please read through paragraph 8. Just paragraph 8, please. The first 4 bullet points. Let me know when you're done. Have you done with paragraph 8?
Yes.
And I understand that you say you didn't have your statement with you, that there may be other areas of your statement that were incorrect. But what appears there under bullets 1 to 4, is that correct? Those things, you told the investigators those things that were false. Firstly, that you'd gone to the house of Mr. William Ruto and were there witnessing a meeting when election violence was planned. You recall that you told that and that was false?
Yes.
And secondly, that you'd mentioned persons by the name of Farouk Kibet, Christopher Casorio, and Solo, who had told members of the Kalenjin community to attack and expel
Mr.
Kikuyu
President,
community.
I think we are in public session.
Your Honours, the witness says that these things never happened. I'm not sure I understand on what basis my learned friend thinks these will be identifying.
It's the same basis to which counsel put that information on a PIS.
On our part, Mr. President, we support that this be conducted in the open.
Your Honours, I'm in the Chamber's hands. I'm happy to do this in private session if necessary.
Mr. President, we are happy to have this conversation in the open. But it is Council's case. He put this information on a PIS, I suppose, for a particular reason, unless we are being told that what is contained in the PIS is of no use.
All right, let's proceed.
Thank you, Your Honours. Obviously, context is everything. Do you recall, is it correct that you made those statements and in your initial statement and that they are false?
Yes.
And thirdly, and this is certainly not identifying, that you falsely stated, point 3, words such as Kimurkelda and Kamama, as used in Mr. Joshua Arap Sang's program on Kass FM's Lene Emet, were code words meant to identify and victimize members of the Kikuyu community. You gave that false statement to the investigators? Is that correct?
Yes.
And just for the record, what does Kimurkelda mean? It's a Kalenjin word, firstly, is that right?
Yes.
And what does it mean?
Kelda in Kalenjins, the word Kelda means teeth. Then Kimur means teeth, which is stained teeth.
And when that word is used to refer to somebody, what does it normally mean? Or to whom is that word generally used to refer?
It is used to refer to any person whose teeth are affected by, is it called chlorosis?
Right. And if in general conversation someone was to say something like, oh, well, the Kimurkelda did this, who would that refer to? Let me rephrase that. You don't seem to understand. Is this word used to refer to any particular ethnicity? People of any particular ethnicity? It's a simple question, sir. Do you not understand?
Can you repeat again?
Is the word Kimurkelda, and for the record it's Kimurkelda, is the word Kimurkelda used to refer to people of any specific ethnicity?
I don't know.
You don't know?
Yes.
Kamama, K-A-M-A-M-A. What does that word mean?
It means your uncle.
And same question, are you aware whether this is used to refer to persons of any particular ethnicity?
I'm not aware.
And then finally, is it correct that you falsely told the investigators that you had witnessed arson and destruction of property during the post-election violence?
Yes.
And the reason why you told the investigators this, as you've confirmed, is set out in your affidavit. And perhaps you can just, in your own words, explain again why you decided to give this false evidence to the investigators.
Yes. Yesterday, I said that in April last year, 2013, I was approached by a certain lady who told me that she had some connection with the ICC. Then she told me that because she was a PNU supporter, I was a PNU supporter. She approached me and told me that she was speaking with some people from the ICC. Then she told me that they were looking for some more witnesses because the key witnesses at that time had started withdrawing. So that the ICC was looking for some witnesses to go and testify. Then she told me that the main intention was to victimize the two, that is William Ruto and Joshua Sang, in the post-election violence that took place in 2007-2008. Then she told me that once you are a witness, you will be able to get a lot of support. You may, your children will go to good schools. You will live a luxurious life. You will pursue further education, and also you will be relocated in the country of your choice and not here in Africa.
Are you then saying that this is what prompted you to give a false statement to the investigators?
Yes, after being promised all those, I saw it was wonderful. Then I joined in giving the false statement.
Your Honor, perhaps we can just for the last few minutes of this session go into private session and just elicit some details about this conversation.
Private session.
We are in open session, Mr. President.
Thank you, Your Honours. Mr. Witness, I can maybe just repeat in public session the topic we're going into now. The lady who you mentioned, who identified to us in private session, you told us that besides telling you of the benefits you might expect as a witness of the ICC, that you had further discussions about the nature of the evidence you were going to give to the ICC. Is that correct?
Yes, correct.
And what were the discussions you had, or what did you discuss about your evidence?
Number one was that I should talk about political rallies that was attended by William Ruto, and if William Ruto was not there, I should mention his close allies or his close friends, because she said that it will be presumed that even if Ruto was not there and his supporters were there, then it will be accepted that Ruto sent them to represent him in that meeting. Two, I should talk about that I attended a meeting at William Ruto's home, and in that meeting it was a planning for attack against the Kikuyu community. Then three, I should talk about the violence that took place in Tarbo and the violence that took place in Eldoret.
Those three things? Is that what you discussed? Nothing else?
It may be there, but maybe I've forgotten.
Would those be the three most important things then that you discussed?
Yes.
And were there any other reasons then that you gave a false statement to the investigators, or was that the primary reason?
That was the primary reason.
Are there any other reasons you can recall now why you decided to give this false statement to the investigators? I'm giving you lots of time to think.
I can't recall any now.
Okay. So, you told the court a while ago that you appreciated the importance of the accuracy of your affidavit. Remember that?
Yes.
And you told us that one of the important reasons why you made this affidavit was to explain the reasons why you would give a false statement to the ICC. You remember that?
Yes.
And both yesterday and today, when I asked you why you would give a false statement, the first thing you mentioned is that it was the lady who we identified that had told you about all the benefits you could get. and who today you also say advised you what sort of false evidence or what evidence you should discuss or give to the ICC. Did I understand you correctly?
Yes.
Can you explain, please, Mr. Witness, help me out here. You've just read through your affidavit. Is there any reason why you didn't tell your attorney what you've told us now about the lady promising you benefits if you became an ICC witness? Is there any reason that's not in this affidavit?
Sorry?
Is there any reason why your affidavit makes no mention of the fact that the lady told you that if you became an ICC witness you would receive many benefits, and that is why you decided to make a false statement? Why is that not here?
Mr. Steinberg. What does paragraph 6 say?
Your Honor, paragraph 6 does not say that the lady was the person who conveyed this information to them. In fact, if one reads in conjunction with earlier paragraphs, it would seem that the inducement was made by somebody completely different, and that's the point I'm getting at.
All right, okay.
I've repeated the question. Do you understand?
Yes.
And what is your answer? Why is that information not here? Yes, we're waiting. Can you hear me?
Can you repeat again, please?
Very well, for the third time. What I want to know is why your affidavit that you attested to before Mr. Mutai makes no mention of the fact that it was in fact the lady who told you that you could get benefits by becoming an ICC witness, and that is why you gave a false statement. Why is that not here?
Can you allow me to read that affidavit once more?
Very well. Mr. Court Officer, can you call up the affidavit at page 1137? But before it's called up, is there nothing you can remember as you sit there now before looking at your statement? Is that a no? Mr. Court Officer, is the document up? With the picture is frozen again.
The document is not up because I understood you wanted the witness to respond before I show it up. If you want me to show it, I can show it now.
Well,
we hear you loud and clear and we see you well.
I think the record should reflect that there was no response. Let's repeat that question one more time so that there's no misunderstanding. You can't recall, as you sit there, any reason why the affidavit does not say that lady firstly told me about benefits I could get if I became a witness, and secondly told me what information to give the investigators. You can't recall any reason for that?
I can't recall that now. Maybe I can read first and then I digest and see.
Okay. We're talking about the statement you read on Tuesday, is that right? The affidavit?
Yes.
All right. Have another look then. It's 1137. Please call it up, sir.
It is being presented to the witness, page 1137.
Now, sorry to interrupt. Carry on.
Paragraphs 3, 4, 5, 6, and 7 are being presented.
Yes. Before you say anything, please don't mention the name of the lady. We're in public session. And perhaps I can just direct you to paragraph 3. You mentioned the lady there. Is that correct?
Yes, I'm there.
Let's just go through that paragraph. You say that I was recruited by, and you gave the name of the lady. And she introduced me to the investigators. Is that right?
Yes.
You can read through the statement if you like, sir, but counsel will correct me if I'm wrong, but there's no other mention of this lady in the statement at all, is there, in the affidavit?
Mr. President, perhaps let the witness be allowed to read this statement, and then he would answer the question.
Your Honours, I'm content to do so. Perhaps may I suggest this? It is now 10 past. Perhaps we should give this witness an hour or an hour and a half to read his statement and familiarise himself with it thoroughly, and we can take it from there when we resume.
All right. That you have no objection to that, counsel?
To reading the affidavit?
Yes. All right, witness, we will now take our lunch break, and we will be back at 2:30. In the meantime, the prosecutor has requested that you be allowed to review that affidavit. Again, look at it, read it carefully. When we return at 2:30, he will continue asking you questions on the affidavit.
Your Honour, if I may just say that there's a further handwritten document that the witness identified yesterday. May I ask him to also have a look at that in the meantime? As well as the handwritten document that you had identified yesterday. Can we be more particular? Yes, Your Honours. It's KenyaMOJA.com 01351140. It's in the nature of a handwritten statement signed by the witness. This is not an affidavit. It's just a statement. All right.
Mr. President, may I request, if it is technically possible, to provide the witness with a hard copy of the affidavit. Perhaps that is better instead of looking at it from a distance on a screen. That makes it a little more difficult.
If it is possible, court officer, to print out the affidavit referred to, as well as KenyaMOJA 01351140 to give to the witness. It would be greatly appreciated. Thank you very much. We'll adjourn now and come back at 2:30.
All rise. We will. All rise. We will obey. Please be seated.
Thank you very much. Mr. Khan, we will dispose of your outstanding request. The Chamber's eighth condition on the excusal from continuous presence of trial does say 5 days of hearing starting after a judicial recess. We will leave it at that, at 5 days of hearing, so that Mr. Ruto will need to be here on Monday.
I'm grateful.
Thank you.
Thank you, Mr. President. May I continue?
Yes, you may.
Good afternoon, Mr. Witness.
Good afternoon.
Were you provided access over the luncheon adjournment to your affidavit and the handwritten statement accompanying it?
Yes.
And did you have occasion to read through it at your leisure?
Yes, I've gone through.
Okay. Can I return then, again without mentioning names, can you confirm that the only time that the name of the lady whose name appears at paragraph 3, the only time she is mentioned is in that paragraph of your statement, is that correct?
Pardon?
Are you having difficulty hearing me, Mr. Witness? Can you hear me clearly?
Yes.
All right, please listen carefully. The lady who you've been speaking of, do you know who I'm talking about?
Yes.
Her name appears at paragraph 3 of your affidavit, correct?
Yes.
Can you confirm that there's no other mention of her other than in paragraph 3 of your affidavit?
Yes.
And can you confirm that there's no mention in your affidavit of her telling you information to the effect that you could receive benefits, financial benefits, by becoming an ICC witness? It's not there, is it?
Yes.
Yes, it's not there.
Yeah.
And it's also not in your statement that this lady told you...
Affidavit.
Affidavit, thank you. It's also not in this affidavit, sir, that you told that... Let me start again. Do you confirm that there's also no mention in this affidavit that this lady discussed with you false evidence to give to the investigators? Is that right?
The affidavit was written in general, so I didn't actually specify some issues, but I wrote it just in general.
Yes, I understand what you're saying, Mr. Witness, but please focus your answer first to my question, and then we can discuss other explanations you might have. Do you confirm that there's no mention in your affidavit that this lady discussed with you false evidence which you should present to the prosecution? Is that correct?
Yes.
Thank you. Court will bear with me. Is this until lunchtime? Yes. I just want to make sure I don't get your words wrong. If you give me 1 minute, please, Mr. Witness. You tell the Chamber, Mr. Witness, why it is that this important reason was not contained in your statement?
Affidavit.
Affidavit, thank you.
Sorry?
We are in open session, Mr. President.
Thank you, Mr. Witness. So you've just explained that by the word that to mean that you should try as much as possible to make people believe they did things even if they never did it. Is that a fair summary of what you said?
Yes.
Was that a word that you used, or was that a word that is used when talking to you?
That is the word they used.
And you go on to say that I cooperated them and gave them false information as requested, as they promised to give me money and finance a luxurious life. Correct?
Correct.
And you then go on to say, again, this is another important part, that the said investigators wanted information or other evidence in regard in William Samoei Ruto's home to plan your recollection of what Mr. Joshua Arap Sang said on the radio during the relevant period, lootings and killings that took place during the post-election violence. The investigators told me that I should fix Mr. Ruto, and where that wasn't possible, his supposed close, and then you name certain persons. Now, isn't that exactly what you said, or almost word for word what you said was told to you by the lady to say? So, which is correct, Mr. Witness? Was it the lady that told you that? Told you that?
What we discussed with the lady, what the lady told me, is what exactly when I said again. So whatever the lady was telling me and what the investigators were telling me was the same.
I see. All right. I'd like to put this aside for one moment, your affidavit, and just ask you one or two questions about your visit to the doctor prior to your testifying. And I'm not going to mention his name in public session, but do you know what I'm talking about? The doctor you visited on the 27th of August?
Mr. President, there is an issue here. You would have noted that since Your Honour's ruling at the outset that my learned friend should probe more before cross-examining or leading, my learned friend almost immediately jumped into cross-examination mode. And I didn't rise, we didn't object. But, Your Honour, in our respectful submission, the spirit of the ruling of the Chamber is clear. That the first task, I'm not saying the prosecution can't do this, the question is when should they do it? And in my respectful submission, given that what we're focusing on is the account, the statement given back to the prosecution, and in particular whether or not the witness is willing to speak the truth or the whole truth or part of the truth today, it's incumbent upon the prosecution before further seeking to discredit their own witness that they probe that statement, do it paragraph by paragraph, and ask him, is that what you said? Is it true? If not, why not? And, Your Honours, we may get to the ultimate point, but there's a certain path that the prosecution need to travel, need to traverse before we get there. And I'd ask that my learned friend from now on be so kind as to conduct himself in that manner that we say is consistent with the ruling of the Chamber.
And also from now on, I think you should be the one making submissions for the rest of this witness's testimony. The matter of you standing up and Mr. Fall as well, yes. That's not something we...
Indeed. Yes. Your Honour, for the sake of clarification, the issues of hostility would be dealt with.
We are in open session, Mr. President.
Thank you, Mr. Witness. We've been dealing with certain evidence that you gave to the investigators relating to incidents that were alleged to have happened to you after the post-election violence. And according to your statement, it says you attended a certain meeting and at that meeting you were threatened because of your position. Some people wanted to kill you, and it was demanded that a cow be provided as punishment. Now, you've told us that you never attended such a meeting. Why did you tell the investigators that you attended a meeting like that?
It is part of the falsehood that I created in order to fit to be a witness.
But can you explain why it was necessary, if, as you say, the meeting did happen and compensation was demanded from a family member of yours, why was it necessary to say that you yourself were at that meeting?
I never got you well.
Why did you think it necessary to tell the investigators that you personally attended the meeting rather than giving them the version which you've just told the chamber, namely that you heard from two sources that the meeting took place and that the persons presiding were demanding compensation from you because of your activities?
I had said earlier that I was told that I should give statement, even if false, but provided it will portray that the post-election violence was planned and there was that revenge mission. So in that matter, I had to fix myself that I went there so that my statement can be more concrete.
I see. This information that you gave in this section, I just want to be clear as to the source of this information. Is this something that you yourself decided to tell the investigators, or is this something that the investigators told you they wanted to have in your statement?
I told them.
You told them. So you made this up, is that right?
Yes.
I see. Thank you. I think we can move on then to another area. Just 1 second. All right. I'd like to turn to some other issues, to follow up on some other issues that you mentioned at the beginning of your evidence. Let's start off with the issue of Mr. Ruto and his position in the Kalenjin community. You recall yesterday that when I asked you what was Mr. Ruto's position in the community, you described him as the point man for the Kalenjin. You recall that?
Yes, I recall.
And I asked you if you could recall any examples or incidents that reflected the influence which he had in the community, and you said you could not recall any such incidents. You recall that?
Yes.
Could I ask the court officer, please, to call up page 0022, ERN 0022 of the same series?
The page 0022 is presented to the witness at paragraph 18.
And I'm interested for the time being from paragraph 20 onwards. Let's go through that. I think this can all be done in public session. Paragraph 20, you state, the leading politician in my area is Honourable William Ruto. Is that correct?
It is correct.
He is referred to as Kirgit, which is a Kalenjin word to mean king. The literal translation of the word is bull, which in the Kalenjin culture is a symbol of power and refers to king. Is that right?
It is not right.
What is incorrect?
From sentence number 2 to where you have stopped.
It's not correct.
Yes.
So, all right. So let's start with the word Kirgit. What does the word Kirgit mean in Kalenjin?
Kirgit means a bull.
It means a bull.
Yes.
Is it correct that that is a symbol of power in the Kalenjin culture?
No.
It's not correct.
Yes.
And it's not correct that it's synonymous with a king.
Yes.
See? Next sentence. Ruto is a mighty person.
Your Honor, again, I don't want to belabor the point. It's supposed to be examination chief. The obvious question is, what does it mean? And does it have any connotations?
Well, I've established the literal meaning. I'm at this stage interested in the meaning, the correctness of the statement. Obviously, my learned friend is more than welcome to ask any follow-up questions he wishes when his turn comes. Or rather, Mr. Fowle's turn comes.
Objection is overruled.
Ruto is a mighty person in the Rift Valley. Is that correct?
No.
What is incorrect about that statement?
That Ruto is a mighty person in Rift Valley.
So, how would you describe Mr. Ruto's position in the Rift Valley? Is he an insignificant person?
Yeah, I describe him to be a leader.
Are there any leaders in the Rift Valley more important than Mr. Ruto?
I think that question vary with individuals. Some people may look him as very important than any other person. Some people may see another leader to be important than Ruto.
Let's not speculate about other people, Mr. Witness. I'm asking you, how would you describe Mr. Ruto? Are there any more important leaders, according to you, in the Rift Valley than Mr. Ruto?
At the present, because he is the deputy president, I don't see any other leader that is above him.
What about in 2007, 2008, at the time of the elections? Were there any other people more important than Mr. Ruto?
Yes, we had other leaders.
Such as?
Such as we had the chairman of the ODM who was called Henry Kosgei.
Was he a more important person in the Rift Valley than Mr. Ruto at the time?
Yes, because he was the party chairman, he was more important.
I see. And what was the relationship between Mr. Ruto and Mr. Kosgei, do you know?
I don't know, but what I know is that they were both leaders of ODM in Rift Valley.
I see. All right. So you say that Mr. Ruto was not a mighty person in the Rift Valley. Going on, by that I mean almost all the inhabitants in my area believe that Ruto determines their fates, and therefore people must follow what he says. Is that right?
No.
What's incorrect?
That Ruto could determine the fate of the people.
Mm-hmm. The statement says that people believed that that he could determine their fate. Is that correct? Whether or not he actually could? Is that correct? People believed he could determine their fates?
Yeah, some people believed.
I see. Now, you give a number of examples in the following paragraph of occasions on which Mr. Ruto, according to you, has shown his influence.
Sorry, Your Honour, before we move on, and I noticed my learned friend was going paragraph by paragraph. Your Honour, there hasn't been a question posed, so there shouldn't be ambiguity. In the last sentence of paragraph 20, and therefore people must follow what he says, does the witness say that is true or not? It's quite important. And Your Honour, I don't want to move on so there's ambiguity in the court record. I think it's part of the question. It hasn't been answered by the witness.
Your Honour, I can certainly clarify that, but perhaps I should get some clarity too. The prosecution will obviously deal with areas of the affidavit which it feels it has to for the purposes of determining what is correct and for the next statement and for the next steps that one might take. Obviously, my learned friend, if there's anything which remains unclear, Mr. Falk can clarify that in his cross-examination. I do not propose to go through each and every word in this statement just for the sake of removing ambiguity. But certainly in this occasion I will follow it up.
Definitely, you can see the importance of that.
Yes, yes, on this occasion I will clarify that.
Also, while you clarify that, in light of a certain distinction the witness has made between time periods, also mindful of the tenses in which words appear on the statements, you might want to clarify what time periods we're talking about.
Yes. Mr. Witness, just to clarify firstly the time periods, the statement is written in 2013, we know, and you state there that Ruto is a mighty person in the Rift Valley. Was that correct in 2013?
I think I didn't admit that Ruto is a mighty person.
So neither in 2007 nor in 2013 would you say that he was a mighty person?
Yes.
All right. Then on the last issue...
Sorry, and just for clarity, Your Honour, because it's important to what Your Honour said, at the time of the statement, Mr. Ruto was already the Deputy President of the Republic of Kenya. So, Your Honour, just for that obvious point.
I noted that.
I'm not sure if that was an objection, Your Honours, but I'll move on.
Move on.
You finish off by saying pertinently, therefore, people must follow what he says, meaning Mr. Ruto. Is that correct?
No, it is not correct.
And in 2007, did people follow what Mr. Ruto said?
What happened in 2007 is that Ruto himself had to follow what the people said.
So it was Mr. Ruto who was following what the people said?
Yeah, in 2007.
I see. Paragraph 21, you give an example of the influence that Mr. Ruto had pertaining to the election of one Wilson Mutai.
I think we are in open session.
And it's not a matter which is identifying at all for yourself. Is that correct? There's nothing in this paragraph that identifies you, Mr. Witness.
I think...
Right, let's do this. Let's go to private session, see what's bothering the witness.
We are in open session, Mr. President.
Thank you. So, Mr. Witness, in the private session, you've just confirmed that various examples that you've given in your statement of Mr. Ruto's supposed influence in the Kalenjin community were incorrect.
Yes.
We're reading through paragraph 29, and we're about halfway through now. You state, end of line 4, in fact, Ruto was installed as the Kalenjin leader back in 2007, but I don't remember well the exact date. Did something like that happen?
Yes, it happened.
So that's correct?
Yes.
How do you know about that?
Yeah, I saw in the media.
You saw in the media?
Yes.
And what does it mean to be installed as the Kalenjin leader?
When you become a Kalenjin leader, you become a consultant. Yeah, and you can advise the people.
You advise the people?
Yes.
Mr. President, just for the record, the statement doesn't say the Kalenjin leader. It says installed as Kalenjin leader, just for the sake of accuracy.
I was going to come to that, and there has been, it is something that requires clarification. I actually, at line 10, I see that Mr. Steinberg is recorded as saying the Kalenjin leader, but what I actually heard him about my own ears was a Kalenjin leader. Now, let's clarify what you meant for purposes of that paragraph, whether you meant the leader or a leader.
Yes.
Or what's of interest at this point?
Well, in fact, as my learned friend points out, what the statement said was, in fact, Ruto was installed as Kalenjin leader. So it doesn't say a Kalenjin leader, it doesn't say the Kalenjin leader.
Yeah, there was no article. There is no article in the statement. The question is, are you interested in one? In terms of the definite article, the Kalenjin leader, or just indefinite as a Kalenjin leader?
Well, perhaps we should explore that with the witness. When your statement says that Mr. Ruto was installed as Kalenjin leader, does that mean leader of the whole Kalenjin or one of many leaders?
I meant one of many leaders.
I see. And I think you were, yes, you told us that he became a consultant and could advise the people. Advise them of what, Mr. Witness?
On political issues.
And when a Kalenjin leader issues advice on political issues, would the Kalenjin people be expected to follow that advice?
Some may follow, some may decline to follow.
See. Would a Kalenjin leader be regarded as an influential person in Kalenjin society? Any Kalenjin leader?
I'm not sure of that.
What does a leader mean? Mr. Witness, is a leader not an influential person?
Yes, leader can be an influential, it can be a servant to the people.
I see. And we're over time, so let me finish up quickly. They are considered, this is now, he viewed to the ultimate authority and only and the only one capable of protecting their interests. I think that should be he was viewed. I'm not sure, but that's what it reads. He viewed to the ultimate authority and the only one capable of protecting their interests, and especially their land against the Kikuyu. Is that correct?
It is not correct.
Those who are against Ruto who are considered outcasts. Is that correct?
It is not correct.
They are considered by the community and they can't get involved in any activity within the community. Correct?
Not correct.
They are verbally abused regularly by other members of the community, which could lead to mental torture. Is that correct?
Not correct.
And I'll just read out the last. There's no need to call up the page. Sometimes they are also victims of physical aggression. Correct?
Not correct.
And this is what happened to all PNU supporters in 2007 and 2008. Is that correct?
Not correct.
So PNU supporters weren't considered outcasts? Kalenjin PNU supporters?
Your Honour, in fairness to the witness, the proposition in the statement was this happened to all PNU supporters, and then my learned friend asks a secondary question which is a little bit different than the all-encompassing all. And it's only fair, I think, to see what the witness said, if it's agreed, and if not, why. Your Honour, otherwise we set up a proposition, and then the following question is something quite different.
Your Honours, I am following up on that question, but perhaps it can be left. I see we're now well over time for Monday morning.
Yes, this is the convenient point to adjourn. We'll take it up again on Monday morning. Witness, we will adjourn for the weekend and we will reconvene on Monday. Please, you will still be warned that you're still under oath and you're still subject to the subpoena. And while you're outside of court, that is in the meantime, you must not discuss your testimony with anybody. Do you understand?
Yes, Your Honour.
All right. Thank you very much. So you rejoin us on Monday. Our court is adjourned for the day.
All rise. We will